May I please your lordship?
Yes.
Lordship, I beg to mention item number 10, lordship. Item number 10 of supplementary hearing, lordship.
Yes.
Lordship, can this matter be posted after 1 week, lordship? I have certain difficulties to take up this matter today.
What difficulty?
Lordship, I have gone through the brief properly, lordship.
Huh?
I had a matter in the court number 1, so I did not have time.
On the prayer of Mr. J.G. the learned counsel for the petition, list this matter after 1 week for hearing.
Much of
If it may please your lordship, I would
Yes.
like to mention item number 1.
1.
May I pray that this matter may be listed next week, your lordship?
Why? There's
Well-
nothing.
You
You have not been allowed to file an appeal
yes, your lordship.
and your delay
My delay application was dismissed, your lordship.
condition has been rejected.
Yes, your lordship.
That's all I thought. Dispose of, allow and send it back.
My lord, I'm not really prepared with the well prepared with the case.
What is there? I have read it. Who's the other side?
Mr. Lawrence.
You have
yes.
said, you have read your petition. It says,
Yes, sir.
when the substantial justice and the technical consideration
Yes,
pitted
sir.
against each other, the
Yes, sir.
substantial justice has to be prepared. On the ground will allow.
All right.
Where's the other side?
He's in court number 1. In this
Huh?
case, we'll
You have taken a consent.
no, your lordship. In that case, the matter may be taken up, your lordship.
No, in that case, I will not take up.
I'm sorry, your lordship. My lord,
On the prayer of MSD Tamuk Learned Counsel for the appellate. List this matter
next week, your lordship.
after a week.
My lord, I also beg to mention item number 9, your lord.
9.
Yes, your lordship. On behalf of the respondent,
Okay. What about petitioner?
we have informed him, your lordship.
What is this?
It pertains to the decision of the deputy commissioner of the decision of the deputy commissioner is under challenge, your lordship.
The deputy commissioner has sent it to the court of additional deputy commissioner.
Yes, your lordship.
So he's agreed. Are you sure?
But I'm not really
Huh?
well versed with the brief, your
But
lordship.
I am well versed. Anyway.
My lord-
MSD Tamuk Learned Counsel appearing on behalf of the respondent. Praised for and granted 3 weeks. 2 weeks,
Next week, your lordship.
1 week time. List this matter after 1 week.
My lord, there's an interim order in favor of the petition that may also be continued.
In favor of you.
No, in favor of the petitioner, since the
Why-
council could not be.
Why
here.
you should mention, have you taken consent?
Yes, your lordship, I have since the
You have
council,
taken consent
yes, your lordship, since no one was here, your lordship, they have.
anyway,
informed.
interim order, first order shall continue.
Obliged, your lordship.
Yes, your lordship, I'd like
Yes.
to mention item number 7,
7,
lordship. The matter may be listed after 3 weeks.
why?
This matter is led by senior counsel Dilip Mazumdar.
DK Devi, Majumdar,
Yes, Dilip Mazumdar.
okay. Any,
No, the
okay, what is the matter?
this is appeal against the judgment passed by the district court KU.
Land dispute
Yes, land dispute.
on the prayer of MS
Somila.
Samaya Learned Counsel appearing on behalf of Mr. D. Majumdar, Learned Senior Counsel appearing for the respondents.
DK Devi for us.
List this matter. List this matter after 3 weeks.
3 weeks.
Mr. S.K. Devi, you are D.K. Devi.
I'm DK Devi.
You are for.
I am for respondents.
Sorry.
Yes,
Is it? She is for
Dilip Mazumdar.
appellant, huh?
Uh,
On behalf of the MS Friends of Learned Counsel, appearing on behalf of Mr. D. Majumdar, Learned Senior Counsel, appearing for appellant. The praise for and granted 3 weeks time. Mr. D.K. Devi, Learned Counsel for the respondents.
Except 10 and 12.
Huh?
Except 10 and 12.
Respondent numbers, except 10 and 12.
Yes.
Why? Service completed
Service,
for
yes.
10 and 12. You asked 10 and 12. As if you are appearing that you also appear for it.
I will ask consent.
Okay.
Yes.
My lord, I beg to mention item number 8. I'm on the behalf of petitioner counsel, Sri Rajesh Waner, who is out of station, would pray to adjourn for 3 weeks.
Why lawyers are not in a mood to argue the matter today? Huh? Your name,
My name is Tadar Taji.
Mr. So and so, learned counsel appearing on behalf of Mr. Rajesh Sonar, learned counsel to the petitioner. Yes, for a granted 3 weeks time.
Yes, sir. 3 weeks.
This is matter after 3 weeks. Mr. T at the learned additional VP Police State present.
May I?
Obligation.
I like to mention item number 2. Yeah, on behalf of Peter,
Ah,
he is under medical treatment.
your name, please.
BC.
Your name is Najee.
Yeah.
Mr. So and so learned counsel appearing on behalf of Mr. T Tapak, learned counsel to the petitioner, submits that the leading counsel, Mr. T Tapak, is undergoing medical treatment. Therefore, press for listing the matter after 4 weeks. 4 weeks. There is a lot list after 4 weeks. We are appearing. Mr. Y. Rida, learned counsel to the learned state counsel present.
May I Lordship, I
Yes.
beg to mention item number 5.
Yes.
As here, Lordship, I have to furnish the newly implemented respondent numbers to his address.
Ah,
Here I have to furnish respondent number to his address, Lordship.
no, we'll see.
Newly implemented.
We'll see it in order state. What for your thought?
I will outside my lord, may I seek a leave of my lord to appear to represent the victim in this case.
Assistant PP.
Yes.
Assist the PP, yes. Your Lordship, status report has been sought for Your Lordship. As per the Your Lordship, the report, Your Lordship, the FIR has been registered under section 376, 506, and section 420 of IPC, Your Lordship. It's a false promise of marriage, perhaps, Your Lordship. Yesterday only it was registered. Yesterday it was registered as per the information.
So, no investigation.
It just registered yesterday on your, now they will investigate the matter, Your Lordship.
So in that case, we'll ask him to appear.
Did I leave it to Your Lordship?
My lord, my humble submission, my lord.
The victim is adult.
Yes,
Yeah,
Your Lordship.
yeah,
Adult,
yeah.
yes.
They have been living together for last 7 years. Nah, but the only problem is that, my lord, this, the lady, poor lady, helpless lady, she has been exploited like anything. Now, the accused person being in police officer, being the officer in charge of the Nahalagan police station.
I filed the report 82 of setting aside.
First time. First time.
Yes.
Well, issue notice.
My lord,
Call for the-
Before coming this, I would like to give a submission regarding the section.
No, today we cannot do anything. We'll just call for the LCR.
LCR, yes, also.
That Mr. So-and-so Leonard comes for the petitioners. And also. And Mr. T at the Leonard Edison. Public prosecutor of the state of Arunachal Pradesh. Next, we're calling this application under section 422 of CRPC 972. The petitioners have paid for compounding the non-compounding offense in connection with and for quashing of the FIR and consequential proceedings in connection with which case in connection with
The normal PS case number 52 of 2007.
GR case,
Yes.
no GR case.
GR case. GR case.
arising out of Narlagan PS case number 52 of 2007. In GR case number,
GR case number,
Your Lordship, actually, they have not,
it's only for quashing the FIR.
but they have not annexed the FIR, Your Lordship.
Annex the FIR.
Only they have annexed the charge sheet, Your Lordship. So they should supposed to file the FIR also, Your Lordship.
my lord, I've actually, this charge sheet is defective. So we have again, apply CPC. Yesterday only we got the CPC.
When you file along with that, they will hear you. You don't file afresh.
Yes,
It has to be in proper format. Otherwise difficult.
Actually, this one, those petitioner, the victim petitioner.
And you are not saying only for
It's like
compounding, you are
the-
not for setting aside the criminal proceedings. You are only for FIR. What is the stage?
It says this is now
Evidence.
PWS.
Huh?
PWS.
Trial commenced.
So you are not praying for quashing of any criminal proceedings. You are only praying for FIR.
My lord.
And you have not annexed the FIR also.
Yes, yes, of
So you
course.
could withdraw it and file afresh. Mr. So-and-so learned consent for the petitioner is permitted to withdraw this petition with a liberty to file a fresh statement.
Oblige, Your Lordship.
My lordship.
Yes,
Lordship, this is a joint application under section 482. Praying for quashing of criminal proceeding of GR case number 164 of 2020, pending before the learned CGM court, Lordship. Lordship,
we'll call for the second copy.
Lordship.
And in the meantime, we'll. Okay,
Lordship,
so serious,
Lordship, this is actually.
serious or serious? Huh?
So this is actually compoundable lordship,
All.
only 419 lordship, because other sections are.
Even if one is there, it is difficult. It will be suffice if one section is not
Lordship.
compoundable.
And lordship
Alright.
here, lordship, 419 is compoundable by the person cheated lordship.
Uh,
And lordship here, they have,
They've approached the trial court.
lordship,
We'll see, it's okay. We'll
Lost.
see.
lordship.
I think that is also under challenge. Rejection is under challenge.
rejection is not under it. Actually, Lordship, the prayer was rejected orally. That was an issue.
Okay. You
So-
could have approached by
Lordship.
filing an appropriate application.
Yes, that
How do we believe the oral rejection?
that is. So
Anyway. Heard Mr.
Jita, Lordship.
Gitalo learned counsel for the petitioners. And MS. And also MS El Hagel learned additional public prosecutor. For the state of Arunachal Pradesh. Next paragraph. By filing this application under section 482 of CRPC 1973. The petitioners have jointly pled for quashing of FIR being LOPS case number 97 2019. And the consequential criminal proceedings in GR case number 164 of 2020 under section 419, 424, 68, 471 of the IPC pending before the Court of Chief Judicial Magistrate on the ground of settlement between the parties. Settlement amongst the parties. Three petitioners, no?
Yes, pardon.
Next paragraph. Call for the scan copy of LCR from the CGM, from the court of CGM. Next paragraph. Pending production of the LCR, the proceedings in GR case number
164, Lordship. 164 of 20.
164 of 2020, pending before the learned CGM shall remain state.
Much obliged.
Obliged.
Please, your lordship. This is a long pending bail application, your lordship. In many occasions, they have taken the adjournment. So, see, your lordship, LCR, perhaps LCR has been received because he is the co-accused and other accused has been charge sheeted and he is still absconding, your lordship.
Absconding.
My lord, prior to charge sheet lordship, we have just received the 41 CRPC notice lordship, and after that we have projected this petition lordship.
Hmm.
In the meantime, charge sheet has been filed. Diary was called for, at that time the charge sheet come. My lord.
If you are absconding, how can the bail be granted to you?
Lordship, I have no knowledge about this case, lordship. Only notice was, it came to my knowledge that when my account was freezed, lordship.
You appear, have you appeared?
No, my lord.
Then you have come to knowledge, you've got the notice. You appear.
Lordship, charge sheet has been filed, lordship. That's why it is up to the,
Okay,
now
okay.
to the
No,
trial
your
court, lordship.
lordship, I will clarify one thing.
Ah.
Lordship. Charge sheet has been filed in connection to the co-accused. He is absconding because of that, this supplementary charge sheet yet to be filed. Supplementary charge sheet. And this case is pertaining to NDPS case, where in section 27A is there. So rigor under section 37 will operate. Even in anticipatory bail, they have to satisfy the two conditions of the NDPS Act, your lordship, because his involvement regarding financing, your lordship. So far as the material is concerned, financing the peddlers, your lordship. So now they.
So dismiss, no ground for bail.
Lordship, I may kindly ask you, lordship,
Either
kindly
you
see.
withdraw it or will I'll dismiss.
Lordship,
Withdraw.
give you opportunity, lordship, to appear before the trial court, lordship.
Do whatever you do,
Yes, lordship.
withdraw or will dismiss.
Withdraw, lordship.
Mr. So-and-so learned counsel for the petitioner. Applicant,
Yes, lordship.
applicant accused. Praise for withdrawal of this bail application. List of Mr. T.F. Learned Edison, public prosecutor. State president. Prayer of the learned counsel for his petitioner in the law.
MLS.
MLS. The accordingly, this bail application is withdrawn, I mean, closed on, disposed upon withdrawal. That's it.
Obliged, deeply obliged, your lordship.
Deeply obliged, lordship.
My lord, service report is still awaited, ma'am. Service report is still awaited, ma'am.
When did you take the step?
Next on 22/05/2025.
This answer notice, answer has been returned back.
Yes, ma'am.
You take a fresh step. What if respondent,
Poor respondent again.
you
Oh.
take a fresh step,
Okay, ma'am.
it's return answer,
Yes, ma'am. My lord, there is the interim.
not Mr.
order.
So-and-so, then counsel for the petitioner. Next para. Office note dated 29/8/2023 indicates that the notices upon the respondent has returned answer with a postal note that addressee not found in given addresses. This next one. The in view of the learned counsel for the petition is directed to take fresh steps by identifying the correct and proper address of the respondent within 2 days.
My lord, there is interim order. Maybe we can take.
Interim order was not yet set continue. We find out it's not, your address is not found. I mean, their address. We find out, I said directed to identify the proper and correct address.
Okay.
Against it. Within 3, not 2 days,
Okay,
within 5 days.
okay. Much okay.
Lordship, here, yet to furnish the name and detail of the respondent number 2. And
You're supposed to,
on last question, Lordship, substitution of respondent number 2 was allowed in I or in order dated 27.
you are supposed to take a step.
Yes,
Why you would not take any? You take a step.
Lordship.
Office note dated 28/8/2023 indicates that the learned counsel the petitioner has not taken steps as yet. Mr. In view of the book, in view of the book, the learned counsel the petitioner is directed to take steps for service upon this newly implemented respondent number 2 within 5 days.
Lordship, there was an interim loss.
Interim order was earlier to continue. What is this, sir?
Lordship, this is a condonation application,
Huh?
condonation application
For,
for condoning the revision of the rejection order passed by the Lanet CGM Court UPR. So here in fact,
What is the provision?
provision 482 CRPC is here.
Yes, what is the provision for limitation?
482, no revision, no limitation.
Then why
here.
you have filed this petition?
And last occasion, I reflected 401 of CRPC, the Lanet PP objecting for this matter should be filed criminal revision
You
petition.
have,
That's why
basically it's 482 or 401?
the both section is there, 482 and 401 of CRPC. And
No,
criminal
that
petition, this is a
114 is
criminal
there.
petition.
Huh?
This is a criminal petition. So for a criminal petition, 482 is there.
401 is a limitation applies. Mr. PP, 401, what is the law, is it limitation?
Revision, it is from lower court to high court, it's 3 months.
Let us see, what is the problem? Is there any order of this court?
No, only prayer of the objection raised from the Lanet PP. I last occasion,
Any order in this matter?
no,
It has not been registered as yet.
only,
You have not moved the main petition, connected revision petition,
yes.
is it?
Yes, only last occasion, only raised question, raised from the
So what's-
occasion.
Four zero one and what?
401 is high court power of revision.
It's okay, that's why I'm saying, what is the limitation?
Limitation, actually, I'm looking for the this direct, but it was not found in our
Huh?
office. So I'm checking out in this mobile. It's 3 months from lower court to high court. What I remember is.
The order is against,
The order is regarding the joint application, compounding application filed by the both party before the Lanet CGM UPR, but Lanet CGM UPR not accept, rejected. So
or
this,
compounding the offences
all the sections are compoundable.
under 320.
Yes, application of file under 320 of CRPC, but Lanet CGM UPR rejected the compounding application. Since the offense, alleged offense.
So
was
revision
compoundable.
doesn't lie before the sessions.
Revision, the time
3 months.
limitation is there.
131. So the 131,
So
3 months, time 90 days.
was
And the order is passed, interim order is passed on
okay, you saw the provision.
limitation period. I'm in mobile, matlab, we have misplaced our bear in office.
Are you sure?
Yes,
One
1
revision, it's
90 days.
it's 90,
Yes,
huh?
yes,
Criminal revision.
yes. Even in civil division also 90 days from one court to another.
We'll take up after some time. You also, since you have filed the application, are you not sure?
I will file on a basis of 482, 482.
482 it was required, 401.
Yes, 401.
You find out. Or we'll list after 4 weeks,
No.
huh? Next week. You
Pass
find
over-
out, you have filed the application,
Pass
other,
over, pass over
Huh?
for a while,
huh?
pass over for some time.
131. Schedule.
What is this Code of Criminal Procedure 1898? Huh? The date of decree or order or sentence sought to be revised. The present CRPC is 1973, it's 1898, why? It has not been amended.
Period
The limitation act.
limitation not yet set.
Hmm?
I suppose not yet amended.
So we'll go by the 1898.
Yes, as per existing statutory law. If not amended. Because publication is, I suppose it is in 2015, latest publications.
Hmm?
Latest publication is 2015.
This 2021
Oh, yes,
publication.
that means no amendment.
Huh?
That means no amendment till 2021.
This has been repealed.
That I have no idea. But limitation cannot be repealed, limitation act.
Huh?
It can be amended, it cannot be
I'm
repealed.
talking about CRPC.
Oh, yes, 18,
18,
that is repealed. Now it's current act is 1973. In the question of limitations, we have to abide by the present statutory act. And in question of
Section.
criminal
Article
procedure.
131 says. Any order or
Judgment,
sentence
yes, sentence.
from the Criminal Procedure Code of 1898.
70.
1898.
Oh.
It says
Sorry.
so. Find out. You also. I think you cannot find out just right now. You
Uh,
need some time.
Actually, burden lies upon him. He prepared for condemnation, and he has to justify. He
No, it's okay. You are also equally
offline.
duty bound, public prosecutor. And
Yes,
Mr. Farooq,
90th.
it's your
Yes.
application.
Yes.
And it is a question also arises how he claims 10 days of delay. On what basis?
He said,
He said 10 days
on
of
the
delay.
basis of your objection, he's filing this IA.
Yes, in earlier proceeding, some other colleague was here.
You have also appeared in this matter.
Yes, now I entered.
Yes, Your Lordship.
He has filed an application, I mean, the revision petition
Yes, Your Lordship.
under 482, read with 401.
Yes, Your Lordship.
So PP objected
Yes,
that this is a delay in filing the revision.
yes, Your Lordship.
So according to him, is section, I mean, article 131
Yes, Your Lordship.
of the Limitation Act,
Yes, Your Lordship.
which is 90 days.
Yes, Your Lordship.
So he has filed this revision beyond 90 days.
Yes.
So on your objection, he has filed this IA,
Yes, I.
not on his own
Yes, in revision, Your Lordship.
understanding of the provision,
Yes, Your Lordship.
but on your objection, he has filed.
Yes, Your Lordship.
So he's handicapped. You want him to file an IA,
Hmm.
so he has filed.
Yes, Your Lordship.
That is the ground he's saying.
Yes, Your Lordship. If delay is more than 90 days, then they have to file this condemnation specifically in the revision, criminal revision.
No, he said it's 482, read with
No, no.
401.
Your Lordship, that is the reason. We have to understand the order, Your Lordship. Because of that only, every time this.
Order is, they have filed an application for compound,
Yes,
compounding the offense.
Yes.
Which all the offense, sections are compounded.
yes.
It has been rejected. Against that order, he has filed.
That is the final order, Your Lordship.
Oh.
Final order revision lies, not 482, Your Lordship. Against.
Now, present petition is 401, read with 482, read with 401 and 397. 397 is a revision. Earlier, withdrawn application was under only
So
482.
397 may be, it may be the limitation.
Yes,
applies.
that's why limitation
I don't
applies.
think 401 is.
Well, that is the reason, Your Lordship. Every time the Supreme Court says one cannot circumvent the provision. You only to condone. the
I'm not
revision.
on that.
Yes,
What I'm
that is the
on
reason, Your
is-
Lordship.
On is,
This we
if
have.
it is 397,
Yes, Your Lordship.
this will apply, but 401 and 482.
Yes, yes,
No,
that will not-
this-
that's correct.
Your Lordship.
401 also applies.
Your Lordship, revision, if this is a final order, Your Lordship. If final order comes, Your Lordship, then there is.
Final order is, then what is the provision of, it's a 397 or 401?
397, Your Lordship. Only interlocutory applications are.
That's what I'm saying.
Yes, Your Lordship.
One has to file in the, one, the provide, which is provided in the statute.
Yes, Your
So
Lordship.
if 397,
Yes,
this will apply.
Yes.
Limitation will apply.
yes,
But 482 and 401, it will not apply.
yes, Your Lordship.
So what is your application? You said 482.
482, 401.
Read with 482,
Read with
401 and
Not,
397.
not 397.
397 for calling of
You
record.
have mentioned.
Yes.
Your Lordship, inherent power has to be exercised when there is no any provision as such for remedy, but 397 is there, Your Lordship, for revision. Then 482 shouldn't be invoked, Your Lordship. In many occasions, the Supreme Court has reiterated, even the High Court, Your Lordship.
So which your application is under which provision? Either 397, 401 or 482.
482.
482, no
Criminal,
IA lies.
criminal petition. Criminal petition
Ah.
number 31.
We'll record it, huh?
Yes,
Be sure.
yes,
If it is 482, no IA is required
no,
for condemnation of delay.
yes, yes,
And the risk will be your petition is man online under 482. All right.
Exceptionally in rare
Risk
case,
involved, I'll
482
say this IA is not maintainable because you have filed an IA for condemnation of delay in the 482 application. So IA is not maintainable.
Yes, yes.
Let me
My lord.
finish it. You take,
My lord.
you be
here,
sure yourself.
My lord, here.
If it is sure 482,
401 is also for revision,
no,
401
no,
is there.
which one you are invoking?
My lord, in fact, this matter should be registered under criminal revision petition. Actually, it should be criminal revision petition. So for that, 401-397 is there. So in regard to that last order, I prayed before this humble court, so I may be allowed to file condemnation application as well as converting this criminal petition into criminal revision petition. Last order.
No, no, if you pray for converting it,
Yes.
first you have to decide
Yes.
whether the application is under 482. There cannot be two.
Yes.
Either it's 401 or 397 or 40.
Yes,
It cannot be
401.
both.
Yes.
Cannot be together.
401 should be. It
Huh?
should be.
Only 401.
Yes, 401, yes. That's why last occasion, my submission I reflected. So I was allowed to file this application.
Which one?
Last order I prayed and same was allowed. So yesterday I filed application for conversion, but it was not in the
No, first
report.
you have to understand whether
Yes.
the condemnation lies or the limitation applies or not.
For a
You
401,
cannot bring all those provisions together.
yes. It's a little,
There's a specific provision
yes.
in how to file.
401 is also revision, your lordship. For revision, 401 revision, 397 revision, your lordship. 482 is extraordinary inherent power which has to be invoked exceptionally in rarest of the rare cases, your lordship. Where there is no any provision to give effect to the order of the court, your lordship. Here there is a provision, your lordship, available. Challenging the final order of the court. His right has been curtailed because of that order. It's a final order, your lordship.
It should be 397.
Exactly, your lordship. Calling for record. Three 97 will apply. 401 specifically in the subsection 1, your lordship, it clearly says, your lordship. It's a discretion also, your lordship. Lordship, may I read the 397 provision, your lordship?
Okay. You first decide yourself. This petition is under what provision?
401.
Because
and
397, the limitation will apply.
yes.
But 482, no limitation.
401.
And 401 is also, there's certain orders and the orders has to be looked into, the nature of the orders.
Yes.
Is it a final or interlocutory? First you decide. Then we'll
This,
come to we'll decide.
this order
It's just
challenging-
not that if somebody files an application, we'll decide it. It's a reason I'm saying.
Yes, yes,
Are you getting me?
yes.
You first examine. I mean,
401
decide yourself.
87.
You decide yourself first. Which petition you would like to file, under what provision? All right. On the prayer of Mr. T. Torum, learned counsel for the petition, list this matter after 2 weeks. Or 1 week.
1 week.
Be sure.
It's 1 week.
Oblige, Your Lordship.
Yes. One. Yes, sir.
Yes, madam. May I please?
Is there any surviving cause?
My lord, as of now. Yes, madam, yes. Yes, madam, there is.
Is it?
Yes, madam.
Your challenge is
Promotion of
of
respondent number 4 and 5.
4 and 5.
Yes, madam. My lord, if I recall,
All the parties.
yes, madam, all the.
I think so.
Just let us refresh.
Let my friend make a submission.
Yes. Well, I will repress the fact of the case.
Yes, yes.
My lord, but this honorable, my lord, court, my lord, permanent bench, eternal permanent bench, it was established in the year 2000. Under the administrative head of deputy registrar. My lord, in the year 2013,
Under the head of
deputy registrar,
deputy registrar.
established in 2000, my lord.
Yes.
My lord, in the year 2013, the then, my lord, deputy registrar has been, my lord, promoted.
Why
to-
we're saying that this was established under the head of deputy registrar, as the administrative head?
Yes, my lord, why I'm saying so, my lord, because, my lord, I like to show, my lord, there is 2 posts of deputy registrar, my lord, of high court services. There are 2 posts of deputy registrar.
It's okay.
Under-
It's a bench was established,
Yes,
permanent
ma'am.
bench.
Yes, ma'am.
Under the high court.
Yes, ma'am.
So if, can we say that deputy registrar is the head of the administration?
At that time, my lord, that point of time,
Huh?
regarding this permanent bench.
From where do you get it?
My lord,
From where do you get it?
my lord, this is my submission, my lord. My lord, there is no.
That is supported,
Yes, my-
because we should not, factually, we should not be, misconstrued.
Yes, my lord,
Anyway.
okay, sir, okay, my lord.
We'll see later there.
Yes, ma'am. In the year 2013, ma'am.
Because initially, at first, blush, I had a doubt that if the bench is established,
Yes, ma'am.
if registrar or the deputy registrar, whatever designation,
Yes, ma'am.
they cannot be called as a administrative head. Because it's under the under the High Court,
High Court of, my lord.
Guwahati High Court.
I am with that, my lord.
Hmm.
My lord, in the year 2013,
Yes,
with, this, the then deputy registrar, my lord, he was been, the then deputy registrar.
then
Yes, ma'am. He
Yes.
has been promoted to post of joint registrar.
Joint registrar.
Yes, ma'am. Thereafter, one for post of deputy registrar has been fallen vacant, my lord. And by this impugn order dated 22nd August 2013, my lord, which is as page 30. Page 30, my lord,
30.
30.
Hmm.
By this order, my lord,
Hmm.
this respondent number 4, my lord.
This is the impugn.
Yes, first impugn order, my lord.
Yes, how many? First, second, third?
2, my lord, two
Huh?
impugn orders. Here. 2 impugn orders. This is the first impugn order, my lord.
Hmm.
By this order, my lord, the respondent number 4, my lord, he was, my lord, brought to this bench by way of posting from principal bench. May I read? In the exigency of public service and in the exercise of power conferred under Article 229 of the Constitution, that the Honorable the Chief Justice of the Guwahati High Court has pleased to post such and such Deputy Registrar Guwahati High Court on transfer against the vacant post of Deputy Registrar Guwahati High Court in usual scale of pay and other allowances as admissible under the rules. By this order, my lord.
This is respondent number 4.
Yes, my lord, respondent number 4.
Yes.
My lord. By this order, my lord, respondent number 4 has been brought to the vacant post of Deputy Registrar, my lord. My lord.
Yes.
Vacant post, one vacant post of Deputy Registrar in this bench, my lord. Thereafter, my lord,
On transfer.
on transfer.
Yes.
Thereafter, my lord, if I take your lordship to page 31, is my lord, order dated 21st of September 2016.
Yes.
By this order, my lord, another one post of Deputy Registrar, my lord, High Court Service, which is found at serial number 3, my lord, was created, my lord. The Governor of Arunachal Pradesh placed a court sanction for creation of polling temporary post under the establishment of Itanagar Permanent Bench, Guwahati High Court, Nahar. Serial 3 is the Deputy Registrar High Court Services, my lord.
Yes.
Well, thereafter, my lord, by this creation of one more post of Deputy Registrar, my lord, there is altogether 2 posts of Deputy Registrar.
One is judicial officer.
My
One
lord,
is service. Huh?
my lord, serial number 3, my lord, is the Deputy
Yes.
Registrar High Court Service, my lord.
There are 2 deputy registrar.
My lord, one is for Judicial Officer Grade
Yes,
3, my lord.
yes.
That is, my lord, judicial side. My lord, this is for
We are
High
not-
Court Service. We are
Who are not concerned.
yes, we are concerned to High Court Services.
Hmm.
My lord, by creation of this one more post, my lord, altogether there is 2 posts of judicial, my lord, Deputy Registrar under High Court Services, my lord, in Itanagar Permanent
Yes.
Bench. My lord, now the claim of the petitioner, my lord, is that, my lord, he is assistant registrar, my lord, under the Itanagar Permanent Bench, my lord.
Peter grade. Peter post.
Peter Post is the assistant registrar, my lord.
Yes.
My lord, if I take your lordship to page 33,
Yes.
this is the representation submitted by the petitioner for consideration of promotion to the post of Deputy Registrar. Herein, my lord, in this representation, my lord, he has mentioned that there is 2 posts of Deputy Registrar in this Itanagar Permanent Bench under High Court Services, my lord. And my lord, one post is already filled up by the, my lord, candidate belonging to, my lord, general category. Therefore, my lord, the another post ought to have been filled up from the, my lord, APST candidates. And my lord, this representation, my lord, was forwarded to the, my lord, Registrar Establishment Guwahati High Court, which is at page 37, for consideration of the petitioner for promotion to the post of Deputy Registrar from the post of Assistant Registrar.
How it is possible? There are 2 posts.
Yes, ma'am.
One is from judicial service. And one is from High Court services.
My lord,
You cannot be, you are not entitled to be promoted in the other post. It
My
should
lord-
be from the judicial officer.
my lord, as I said earlier, my lord, when this, my lord, permanent base has been established, my lord, there is already one post of Deputy Registrar. And that is from High Court Services. And after creation of one more post in the year 2016, now, there is 2 posts of Deputy Registrar under High Court Services. And the contention of the petitioner is that, my lord, this one post of Deputy Registrar, my lord, has been filled up in the year 2013 by way of transfer
from a general candidate, my lord. The other post which was created on year 2016.
So total there are 3 posts.
Total there is 3 posts, my lord, 2 for High Court services and 1 for my lord judicial services.
Okay.
Yes, there is 3 posts.
Total 3
3 posts.
in this bench,
Yes, in this.
in this registry.
Yes, ma'am. Deputy register, ma'am. There is 3 posts.
3 posts.
3 posts.
Okay.
Now, my lord, the representation, my lord, which was submitted by the petitioner was forwarded to the, my lord, Registrar Establishment, Guwahati High Court, which is at page 37 for consideration. Page 37. My lord. This is the forwarding of, my lord, the representation of the petitioner for promotion to the post of deputy registrar from the post of assistant registrar. My lord, while my lord, this petitioner is under legitimate expectation, my lord, that his case would be, my lord, suitably, my lord, considered, my lord. To the, my lord, the price of the petitioner, my lord. The second, my lord, impugned order, which is at page 39, my lord, was issued, my lord, on order dated that is 9th June 2017.
This is second impugn.
Yes, ma'am. This is second impugned order, my lord. And by this impugned order, my lord, instead of, my lord, promoting the petitioner, my lord, the respondent number 5 was promoted.
Your claim, basis of the claim is the reservation.
Yes, my lord, I will come to that point.
Yes, since there are 2 posts, one has to go to scheduled tribe.
Yes, ma'am. Yes, ma'am.
What is the rules?
My lord. Now, my lord, so if I come to rule, my lord.
In that case, you are not agreed by the first impugned order.
My lord, if I go with the reservation policy, my lord, as for reservation policy, my lord, there is 100-point proportion. And my lord, past post has to be.
In that case, the issue will be whether the reservation policy of the state will be applicable, I mean, made applicable in this.
Yes,
High Court
exactly,
services.
exactly.
That is the issue.
That is the issue.
That is the reason Learned Advocate General has been requested.
Yes, ma'am.
That's all.
Exactly. My lord, I have, my lord.
So you have, your claim is that there are 2 posts.
Yes, ma'am.
One is being filled up by the non-APST,
Yes, ma'am.
and the next should have been, ought to have been filled up by APST.
Yes, ma'am.
And
My
the impugned order, the second impugned order is, you are basically agreed by you.
Yes,
second
ma'am.
impugned order. You cannot have both 2 by nature of your, submission.
Yes, ma'am.
So you dropped the idea of this first impugned order.
2013 over.
13.
I
It has
was
nothing to do with-
concerned to this 2017 order.
You are only at the highest. If
Yes,
your
ma'am.
claim is, I mean, correct or accepted by this 2019 order only,
17 months.
second 17,
Yes, ma'am.
page 39,
Yes,
second impugned order.
Yes,
Huh?
yes, ma'am.
So then tell us how this reservation policy of the state
Yes, ma'am.
having a different recruitment rules of different various different rules of their own can be made applicable to the services of
Yes,
the
ma'am.
High Court.
Yes, my lord. So I'm coming to that, my lord. Before that, my lord, may I take your lordship to Guwahati High Court Services Rule, 1967. My lord, my lord, it is not.
67.
Yes, my lord, 1960. Page number 636, my lord.
Hmm.
Page
Yes,
636.
yes. Provision.
Provision, my lord,
11 rule.
my lord, is rule 6, my lord. This is regarding appointment, my lord. How appointment has to be made, my lord.
Rule 6.
Rule 6, my lord. Rule
Page-
6, 7.
Rule 68 page.
My lord, relevant will be rule 7, my lord. 640, page 640.
640.
Yes, my lord. Rule 7, sub rule 2, my lord.
640, please.
Gazetted officers.
Yes, gazette officers, my lord, sub rule 2, my lord. Sub rule 2, my lord. The appointment of a deputy registrar shall be from the state judicial service grade 3 or by promotion of a gazetted officer in the high court service belonging to class 2 capital A having a degree in law from a recognized university or by direct recruitment of an advocate having not less than 7 years continuous practice at the bar. My lord, the petitioner, my lord, as well as the, my lord, private respondent are, my lord, class 2A, my lord, class 2A officer having degree in law, my lord, that is not disputed, my lord.
You are having a degree in law
Yes, ma'am.
and you are class 2A,
Class 2A, ma'am. Category class 2A,
assistant registrar.
assistant registrar. My lord, that is not disputed, my lord. My lord, in this, my lord, service rule, my lord, if I take your lordship to, my lord, page 647, my lord. Rule 8, 647, my lord, rule 8. Schedule 5 other backward classes and more backward classes, my lord. My lord, in this intra rules, my lord, this Guwahati High Court service rules, my lord, there is no provision for, my lord, reservation. No provision was made for reservation in regard to promotion. And this rule 8, my lord, is speak about, my lord, reservation for some, my lord, particular section of, my lord, people for direct recruitment.
Yes.
But for the promotion, my lord, there is no any provision. This is for direct recruitment only. And why I'm pointing it out, my lord,
Yes.
there is in this rules, my lord, for promotion, there is no any provision for reservation, my lord. But which ought to have, my lord, made, my lord.
Until the time it is made, what is the question? What is the basis of your claim?
Yes, my lord, as I'm coming to that point, my lord.
Yes.
Why I'm saying so, my lord.
Under the rules, there is no provision.
Provision for promotion,
So you are considering that you cannot claim based on the rules.
not on the based on the rules.
As per the rule
but-
67,
Yes,
there is no provision,
no provision.
only for direct recruit.
Yes, ma'am.
No,
But my lord, in my humble submission, my lord.
ought to have met, that is something different.
Yes, ma'am. Ought to
That
have.
is something,
Why I'm saying so, my lord? If I take your lordship to, my lord, the constitution, my lord, provisions of constitution, my lord.
rule making power
Yes, my lord.
of the chief justice.
Yes, my lord. Article 229, my lord,
Yes,
subsection 2. Article 229, my lord. Clause 2, I'm sorry, clause 2. This is regarding officials and servant and the expenses of high court. This is regarding officers and servant and the expenses of high court. Clause 2, my lord.
yes,
Subject to the provisions of any law made by the legislature of the state, the conditions of service of officers and servants of a high court shall be such as may be prescribed by rules made by the chief justice of the court or by some other judges or officer of the court authorized by the chief justice to make rules for the purpose. Provided that the rules made under this clause shall so far is they relate to salary allowances, leave or pensions, require the approval of governor of the state. Well, I'm concerned to the sentence which start is subject to the provisions of any law made by the legislature of the state. My lord, the Honorable Chief Justice, my lord, on his administrative side. Right? He has power under Article 229 to make rules for which governs the conditions of service of officer and servants of the High Court. But that rule should be subject to the provisions of law made by the legislature of the state.
Yes.
My lord.
According to the reservation policy of the state is a law made by the legislature.
Yes, my lord. I'm coming to my petition, my lord.
Yes.
My lord, that's reservation policy of the state, man. May I take your lordship to page 19. Man. Page 19, my lord, of my petition.
You said subject to your basis is subject to the provision of any law made by the legislature of the state.
Yes, my lord.
The condition of service, you have to read together.
Yes,
The
my lord.
conditions of service of officers and service of High Court shall be such as may be prescribed by the rules.
Made by the Chief Justice of the
Justice.
High Court or some other judge or officer of the
Probably,
court.
perhaps it would be, suppose if you make a rules,
Yes, my lord.
then it is subject to the law made by the legislature.
Yes, my lord.
If the rule is not made
My lord.
at all,
My lord.
was the question of subject.
My lord, that is true, my lord. My lord,
Isn't that it?
that I agree.
Any rules,
Yes, my lord.
it will subject to the law made by legislature.
My-
This is what this provides.
My-
This provision provides close to.
Yes, my lord.
It's not that if rule is not made
My lord.
regarding particular areas or particular subject,
Yes, my lord.
there is no question of, subject to the law made by legislature. This is empty.
My lord, my lord.
It's
but-
always, we'll understand the law made by the, the authority under this clause.
My lord.
Cannot have, it should have in consonance with the law made by the legislature,
Yes, my lord.
isn't it?
But my lord.
But if it is not met,
Yes, my lord.
it has been omitted to be met, then,
My lord, in my
so
humble
your
submission-
question, your grievances would be, you ought to have made a rule. You have ought to have provides, frame a rule concerning the,
Reservation.
reservation.
My lord, that
As
is,
on today, there is nothing
yes, my lord. That is,
estimated.
that is one limb of my argument. My another limb of my argument is, my lord.
Yes,
My lord, if there is any rule regarding reservation, my lord, by virtue of this notification, which is as page 19, it will applicable.
there is page 19.
Yes, my lord, page.
So first limb is gone.
Firstly, my lord, I'm coming to that point also.
No, don't come back again. Just clear this first.
Since
First
my lord,
limb
since
you
my
clear.
lord has make inquiry, my lord, that's why I'm.
First clear the, yourself, make yourself clear about the first limb. Will
Yes,
not go back and forth.
My lord, regarding that, my lord,
Ah,
if I take your lordship.
that is
to-
first limb of the, this thing, your submissions.
Yes, my lord.
It is, you are relying for this first limb or second limb?
2014,
First
yes,
limb. First limb of
2014,
argument.
14 is page 50.
Hmm.
2014. 14 is page 50.
14 SCC.
Yes, my lord.
Yes.
50. Page 50, my lord.
50.
Yes, my lord. My lord,
Correct.
kindly, my lord, take note of it, my lord. This order has been passed on decide, my lord. This judgment was passed on 12th February 2014. my lord.
Yes.
And my lord, if I come to my lord, para 34, my lord.
Huh?
Page 67, para 34, my lord.
34.
Yes, ma'am.
Hmm.
page of 34, my lord. My lord, by this judgment, certain direction has been issued to all the high courts across the state for making reservation for the scheduled tribes, scheduled caste, and other backward classes in high court services. Since, my lord, there are many high courts wherein this reservation provision is not in the rules. Because of that, my lord, by this para 34, my lord, the Honorable Supreme Court has issued direction to the high courts of all across the country, my lord, to implement the reservation which is given under Article 16(4) of the Constitution.
Reservation is not 14 and 16.
Reservation, my lord,
It's an enabling provision.
that's I agree, my lord, that's enabling provision, but under my lord, enabling provision, my lord, the government has given my lord power to make law or say my lord, rules or say my lord, guidelines for implementation of that my lord, Article 16(4) in my humble service. And my lord, by this my lord judgment, Honorable Supreme Court has directed all the high courts to implement that.
Not
Till
that-
then, my lord, in our
You read this paragraph, you read this, no direction, advised. Huh?
my lord,
Read the paragraph.
34 and 35, my lord. they are
Yes, read the 34.
In view of the appeal standard disposed with the following direction. 35(1), my lord. All the high courts are requested to revisit the statutory rules dealing with the appointment of staff in the high courts as well as in the subordinate court. That in any case, any of the rule is not in conformity and consonance with the provision of Article 14 and 16 of the Constitution, the same shall may be modified. And in my humble submission, my lord, this rule, my lord, this 1961 rules, my lord, since there is no any provision, my lord, in terms of this, my lord, direction, my lord, rules ought to have in, my lord, bring in under the service rule. And that is not done.
So
Till that,
in that case, you have to show
Yes, my lord.
appointment includes the promotion.
My lord.
Appointment includes promotion, according to you. If you rely on this judgment,
My lord.
all the high courts are requested to so and so dealing with the appointment of staff in the high court. So you have to show that promotion, in
Yes,
your case, it's a promotion,
My lord.
includes the appointment includes the promotion. Anyway,
My lord, hitting the point.
according to you, appointment includes promotion.
My lord, yes, my lord, appointment goes promotion.
Hmm.
And my lord, is for my lord.
I don't know, I'm just asking you.
Yes, my lord. Is for my lord,
According to you,
my lord, in my humble submission, my lord, I will say, my lord, page 19, if I take page 19, which is the reservation policy of the state, my lord,
huh?
which is the reservation policy of the state. my
Okay,
lord.
by relying this, you are said that this judgment was rendered in 2014.
Yes, my lord.
And as per this judgment, the High Court ought to have modified or to have made a rule
Appropriate, my lord.
providing the
Reservation.
reservation policy in the equipment rules,
In the high court.
which
Yes,
is yet to be done.
yes,
Till
yes,
then,
yes,
till then.
my lord, that is.
So there is a violation of the Honorable Supreme Court direction by the High Court
My lord.
in administrative side.
Yes, my lord,
Huh?
administrative side, I'll say that, my lord. And my lord,
There are 34 and 35.
35, man.
So there is a violation of the Supreme Court judgment
Yes, my lord.
in Renu versus District Decision Judge.
Yes, my lord. And my lord,
Page, what is your, page 19?
page 19. Page 19, this is the reservation policy of the state, my lord.
Is it the latest?
Latest is, my lord, page 25, my lord.
You will go by the latest.
Yes, my lord.
Huh?
Yes, my lord.
Why should go for the outdated one?
Page 25, my lord. Is 1st February 2001. 1st of February 2001.
Page 25.
25.
Partial modification, promotion within group D.
My lord, is partial modification of this 19 notification, my lord.
Yours is promotion from group B to group A.
From my lord, Roman 4, my lord.
Yes.
Promotion from
Group B to group A.
and
And within group A.
50%.
Hmm.
50%, my lord. My lord, in my humble submission,
You just read this
yes, my lord.
notification.
The partial modification of government of notification of event number dated such and such, the governor of Arunachal Pradesh is pleased to make reservation in matters of promotion to the following classes of post in the services under the government of Arunachal Pradesh in favor of
Classes of post in the services under the government of Arunachal Pradesh. Huh?
in favor of Arunachal Pradesh civil tribes officers and officers shown against each group within immediate effect.
See,
Yes, ma'am.
the rule making power and authority of the state
Yes,
and the rule making power and authority of the High Court, they have different provisions.
ma'am.
General and learned senior counsel, but then the reservation policy,
Ma'am.
this is by the governor, the state.
Ma'am.
This is under which provision of the constitution?
My lord, this reservation, my lord, policy, my lord. Though it's my lord,
State is a party other than,
yes, yes, ma'am. They state
I
is
mean,
party.
other than
Yes.
this court's
Yeah.
request is the respondent.
Yes,
Huh?
ma'am. His party, ma'am.
Yes, yes.
The state is the party. My lord, although my lord, this notification ma'am, was issued, my lord.
Is it your case that since the High Court, the third bench
My lord.
is situated in the state of Arunachal Pradesh, though under the Guwahati High Court,
Ma'am.
the reservation policy of the state will automatically apply in the absence of a specific provision in the Guwahati High Court service rules. Is it your case?
My lord.
Because you cannot have two contradictory submissions.
Yes, ma'am.
Either you have to first limb, we are still on the first limb.
Ma'am, ma'am.
We are trying to enter in the second limb, is not it?
Yes, ma'am.
I think first limb is over.
Huh?
First limb, you said the any rule
Hello.
made by the High Court will be subject to law made by legislature.
Exactly.
So let us understand that there is no law as such as on that, so far as the reservation is concerned for promotion. It's only direct recruit. Rule 8, correct?
Ma'am.
Now you are relying on a judgment of the Renew 2014
Ma'am.
that Supreme Court has directed to frame a rule or modify a rule in consonance with the Article 14 and 16. And you have not done it. In 2017, you have promoted the respondent number 5.
Yes.
So you ought to have made a rule providing the reservation
Yes, ma'am. Ought to happen.
according to you.
And
That's why I'm saying, under what provisions of the Constitution or any other provision, the High Court can make a rules providing a reservation.
My lord, I will come to that point also. Well, reported, my lord. So my lord, kindly, my lord, see this page 19.
Yes.
This reservation, my lord, policy was issued under clause 4 of Article 16, my lord.
Yes.
Article 16, clause 4, my lord. My lord, as your lordship has already pointed it out, my lord. The clause 4 is enabling provision, my lord. Article 16, my lord. Clause 4, my lord. Article 16, my lord. Clause 4, nothing in this article shall prevent the state from making any provision.
It's okay, we have
Yes, ma'am.
understood that.
Yes,
What I must, my query is, what is the provisions of the constitution and any other thing,
Yes, ma'am.
where the High Court can make a reservation?
Now, my lord, under this clause 4, my lord.
Will we interpret in such a way, or is there any law as in today that the state under 16(4) includes the High Court?
No, my lord, I think that will be not.
Of course,
proper, my lord,
they may-
my
they
lord,
may-
subject to
they
what,
may-
my lord.
they may come up with-
They may come. But my lord, in my lord, humble understanding, my lord, this clause 4 enables the government to frame a rule or law, my lord.
No dispute.
Yes, no dispute.
No quarrel.
And for that, my lord, in my humble submission, my lord, the state has, my lord, or make rules under, my lord, 3 provisions of the constitution. my lord.
Forget about the state.
Yes, ma'am.
Your services guide by the, will be regulated or is regulated by the rules made by the High Court. 229.
My lord, in my humble submission, my lord, this notification, my lord, is, my lord, in my humble submission, is issued under Article 162 of the Constitution, my lord. That is the executive power of the state to make a, my lord, rule of law, my lord, which is, my lord, subject matter of law to be made by the state legislature. And they are, my lord, co-extensive, my lord. In absence of any statutory, my lord, in absence of any law made by the legislature.
That's why I've indicated,
Yes, ma'am.
had there been a rule not consonant with the law made by legislature, then matter would have been different. There's no rule as such. There's no law, rules made by the High Court.
But
With regard to the reservation,
yes, ma'am.
which we may say that it is not consonant or inconsistent with Article 14 and 16 or the law made by legislation. There's no rule as of today, or there is no provision of reservation made by the High Court, where we can say that it is not consonant or it is inconsistent with the provision of Article 14, 16 or the law made by the legislature. Unless there is any provisions, till that according to you, and as you have seen also, there is no law, rules made by the High Court. So was a question of inconsistency or not consonance with the 14 and 16?
In my humble submission, as I, my lord, submitted earlier, my lord, although, my lord, in service rule, what we have called service rule, my lord, there is no provision for reservation. But, my lord, by virtue of this, my lord, enable provision in Article 16(4), the reservation policy has been framed by a state of Arunachal Pradesh, my lord, which is a, my lord, page 19 and 25.
Will be automatically applicable.
And my lord, this reservation policy, my lord, though it said it's a notification, but it is, my lord,
Law made by the
law,
legislature. As good as law made by the legislature, in view of the
law made by
Article
the
162.
162. And, my lord, any subject matter which regulate the service in condition of the employee, though it is not, my lord,
Reservation is a condition of service.
my lord, because it's connected to promotion, man. It will, my lord, condition.
Is it? I'm
In my-
asking. I don't-
In my humble submission, yes, ma'am. Because promotion is connected with this reservation. Because my promotion, the condition of my promotion will be, my lord, affected by this.
Yes.
Yes, ma'am.
No. Condition of promotion is one thing. The condition of service as such is different, quite different.
But condition in service
So-
my lord,
so-
includes also promotion.
Huh?
And in promotion, my lord,
Promotion can be a condition of service. And the condition for promotion is something different. That is what I'm trying to tell you.
my lord, in my humble submission. my
There's a
lord.
difference. Condition of service,
Yes, my lord.
the promotion, whatever, etc., the condition of service, maybe transfer and all other things. But condition of promotion is quite different. It is somewhere in the friction the complementary thing.
But my lord, I try to
So,
convince. you-
so according to you, the reservation
Yes, my lord.
is also a condition of service.
Yes, my lord. Reservation in regard to promotion. My lord, this is,
Reservation is in fact, it's not we call it, I mean, we may call it a concession. What is the basis of reservation? To have a reservation policy. It's as good as a concession. Anyway, please proceed.
yes. And if I, my lord, say, my lord, this reservation, my lord, it includes in condition of service. my lord. Although, my lord, this rules, my lord, or this notification or this circular, my lord, is issued by the executive, my lord. It will treated at par with the provisions of proviso to Article 309. The rules issued in the Article 309.
So let us assume.
Yes.
Let us treat this as good as, not as good as, let us treat this as a law made by legislation. What is the inconsistency or not consonance to the law made by legislation? What is the provision of by the High Court, framed by the High Court? Which we can say that this is not consistent with the law made by legislation. That is a requirement of
Yes, ma'am.
229 clause 2.
Close to my lord.
Ah. So first you have to show
Yes, my lord.
that there is a provisions of the rules made by the High Court, which is inconsistent with the, or is not in terms of the clause 2 of Article 229.
My lord,
You have shown
Yes,
there's
ma'am.
no rule, there is no rule so far as the promotion is concerned
yes, ma'am.
with regard to the reservation. There's no reservation for promotion in the rules of 1967. Then on what basis you are saying that when there is no rule or provision, that it is not consonance? I mean, subject to law made by legislature, that means the other way we say that the rules, you cannot make a rules, I mean, which is not consistent or consonance with the law made by the legislature.
My lord, in my humble submission, my lord, although there is no any, my lord, reservation
No,
in-
ultimately,
Yes, my lord. But my lord,
what I have understood from
Yes,
your
ma'am.
submission and what you are trying to, I mean, make of your case is that though there is no provision for reservation under the High Court rules
Yes,
of
ma'am.
1967, since there is a reservation policy of the state,
yes, ma'am.
which is as good as the law made by legislature,
My lord,
it applies
yes, ma'am.
even for the service of the employees of the High Court, which is situated in the state of Arunachal Pradesh. Is not it?
My lord, yes,
That is
ma'am.
that is your submission. I mean,
That
that
is
is your,
my submission.
ah.
My lord, since my lord, there is no any provision has made in this.
So why, how this has to be applied automatically? Why?
Why I'm saying so, my lord? My lord, any rule which has to be made, ma'am, it will be subject to the provisions of law made by the legislature.
There is no rule has been made.
That's why, my lord, they have not made rules, my lord, in consonance with the law made by
There isn't
legislature.
a rule.
Yes, my lord. My lord, I'm not.
It is always subject to the law made by legislature. That means you cannot have a rules or provision of the rules which is not against or contrary to the law made by the legislature.
My lord, my submission, my
Not making a rule, not having a provision. Can we say that since there is no rule or there is no provision, it is contrary to the law made by legislation, is not it?
My lord, in my humble submission, my lord,
Yes.
I'm not submitting that, my lord. There is inconsistency between this rule made by the state, which is reservation policy, and the rule made by the High Court. I'm not submitting.
No,
My
indirectly
submission-
that is.
Yes, my submission is that.
You
my
may
lord,
not be submitting that in that black and white language,
my lord,
but then it amounts to that only. Suppose you are saying any law and rule made by the High Court is subject to law made by legislation as per clause 2 of Article 29. If law is not made, what's the question of subject to law made by legislation?
in my humble submission, my lord, since my lord,
Or are you saying
yes, my
not having a rule or provision in the rules of 1967 with regard to the reservation, it is subject to the legislation, law made by legislation.
my lord, I will.
What do you mean by subject to the legislation? The rules made by the High Court shall be subject to the law made by the legislature. What do you mean by that? Please
My lord,
explain.
in my humble submission,
Yes.
in my humble submission, my lord, subject to the provisions, my lord, in my humble submission, my lord, if there is any rule made by the legislature of the state, my lord, while, my lord, incorporating this, my lord, service rule, that will not be inconsistent or contrary, and also, my lord, it should be there in service rule. And anything done, my lord, which, although there is provision in law made by legislature, but that is not incorporated in service rule, my lord, that is also covered under this
Subject to.
subject to provisions. my lord. In my
The
humble submission.
expression subject to.
Yes, ma'am, in my,
No provision also, it covers.
my lord.
Therefore, any law made by legislation, in the present case, assuming that, accepting that the reservation policy is as good as or a law made by the legislation.
Legislature, my lord.
Therefore, even if there's the omission of provision for reservation, this will apply.
It should be.
In
applied.
view of the section, subclause 2 of section, Article 229.
As
This is
well,
what
my-
you're
as well as my lord, Article 16(4)
Ah,
of the Constitution.
that's why I'm asking.
And my lord, this.
If Article 16, whether it includes, can we interpret in a way that it includes the High Court? When you talk about the state,
My lord, since, my lord, this Article 16(4), my lord, there is no any distinction, my lord, whether it is applicable to any field or it is not applicable to any field. my lord. It is general in application in my humble submission.
okay. Or
Regarding, my lord, regarding, my lord, if, my lord, I think my lord is already, my lord, made an observation, my lord, this reservation policy made by the state, my lord, is as good as my lord, law made by the legislation, my lord. My lord has already observed, my lord, that this reservation policy, which was issued by the state of Arunachal, my lord, is as good as a law made by the legislature, my lord, as good as a law made by the legislation.
no, that's why I'm just saying this way. This clause 4 of Article 16,
My lord,
you are saying that this is a law. Is as good as law made by the legislature. You just read Article 14.
14, my lord,
14, no, 16, 16(4).
16(4). Nothing in this article shall prevent the state from making any provision for reservation of appointments or posts in favor of any backward classes of citizens, which in the opinion of the state is not adequately represented in the service under the state. Under the state.
No, that's why I precisely ask you that whether it includes, is it bounded duty of the, say, in this case, the High Court to make a reservation policy or have a provision for reservation under Article 14.
My lord, in a humble.
Because
sense,
it's a enabling provision.
enable, my lord, that is true, my lord, it is enable provision. But my lord, this
So
provision-
your submission appears to be little contradictory. If I correctly understood.
my lord,
One way you are saying that since there is a reservation policy of the state is, which is a law made by the legislature,
my lord, at par with me.
at par or whatever, as good as. So this will apply to the services of the High Court employee,
My lord.
number one. Number two, other one is, you are saying that since there's no provision for reservation under the rule, so far as the promotion is concerned. But as is renew and other constitutional provisions of making reservation, the High Court ought to have provided framed a rule for reservation. Is it are these submissions not contradictory?
My lord,
Either you have to say this applies because there is a reservation policy enacted or framed by, by the state,
that's why, my lord. I am
number
sorry.
one,
Yes, my lord.
or else you cannot have these two together.
My lord, that's why my submission is that, my lord. Even then, my lord, there is no any provision.
Suppose if it is not applied, they ought to have made a rule. That cannot be. That cannot be accepted.
No. So my submission is not, my submission is.
No, that is what I have understood from
Yes,
your submission.
Even if, my lord, there is no provision of reservation in service rule, my lord, it will apply. Because the law says, my lord, this Article 229 clause 2 says, my lord, it will be subject to the provisions of provisions.
Ah,
law made by the state.
then we
Yes,
can
that is
examine
my assumption.
that we are,
Yes.
will examine and we'll see.
Yes, my lord.
That's why I'm asking.
Why I'm submitting, my lord, that.
You stick to your own one point.
Yes, my lord.
Don't have a little, you want, one way you are saying that there ought to have been provision as per the Renu and
Yes,
Supreme
ma'am.
Court judgment.
And because my
If
lord,
there is no provision also, you are saying there is a reservation policy which should be applied.
yes, ma'am. My lord, on record, my lord, I have to, my lord, so this wonderful court, my lord, on record, there is no provision. I have to say, my lord. But I'm sorry, my lord,
It's
but
okay.
my submission is that all, even though, my lord, there is no any provision
Yeah,
in the service rule, my lord, in terms of Article 229 clause 2, my lord, if there is any law made by the legislature, it will apply. my lord. And it will be subject to the provisions of my lord. This power under Article 229 clause 2 will be subject to provision of law made by the statement. That law, my lord, is already there in the state of Arunachal Pradesh. And that has to apply, my lord, while this selection or appointment has to be made. my lord.
because the High Court is situated in the state of Arunachal Pradesh. Is it?
Since, my lord, this, although, my lord, High Court services, my lord, is, my lord, under the control of, my lord, principal seated Guwahati, my lord. But, my
So,
lord,
so
this case-
finally, your submission is, though there is no provision for reservation
No.
for the, in respect of the promotion,
No.
under the rules of Guwahati High Court, the reservation policy of the state will apply for the, in the case of the petitioner or services or employees of the services of the High Court employees, as the service or the bench or the High Court is situated in the state of Arunachal Pradesh. Is it?
Yes, ma'am.
Huh?
Yes, ma'am.
Is it?
Yes, ma'am.
That's all. Anything else? In view of the clause 2 of the article 229. Is not it?
Yes. And 16,
Your submission and your is on the basis of the 229.
229 clause 2, my lord.
Yes. Any other judgment?
My lord, one judgment, my lord.
How many judgment do you have?
My lord, two, just one more, my lord, one more. Whether, my lord, the question before this full bench of Bombay High Court, my lord, whether the circular orders or regulation or part thereof laying down the rules and principle of general application, which have observed in recruitment or fixation of senior recruit. My lord, whether it will be treated is a law made under a proviso to Article 309. That has been discussed in this.
No, we're not concerned.
Not concerned.
Anyway, you give it, if you are not concerned, I think it is not required also.
Yes, okay.
But to have a academic, thing. Paragraph,
My lord, paragraph, my lord, relevant paragraph will start from my lord. Stick, I'm sorry.
I think there should not be any quarrel. 309 and 229 is a different and a complete distinct provision, under the constitution.
14, my lord. 14, paragraph.
Tomorrow you
14.
may say that this was placed and it was not been considered for that purpose.
No. I'm not, my lord, on that purpose.
But else and you take it back by unnecessary burden.
My lord,
It's not related to the issue.
my lord.
Okay. Anything else?
My lord, that's all. Oblige.
In this matter,
Yes.
first, my lord, I would like to make one or two things very clear. Your lordship will kindly take up the government's affidavit. Basically, at para 14, what we have said essentially is that this is an internal matter of the High Court.
Respondent number 1 and 2.
This is by 1 and 2. Yes.
Yes.
If your lordship will straight away come to para 14. This is the stand taken by the government.
Which is very unfortunate. Huh?
No, I won't say unfortunate.
Yes.
I think this is the right approach.
Okay.
That with regard to the statements made in paragraph 14 and 15 of the repetition, the humble answering deponent reiterates the position as stated in para 2 and 5 that for promotion in group A, 50% is reserved for bona fide scheduled tribe of Arunachal Pradesh as per the existing reservation policy of the state. However, as regards the allegation of the petitioner for non-consideration of for promotion to the vacant post of deputy registrar subsequently filled up by the private respondent number 4 and 5 under the establishment of Itanagar Permanent Bench of Guwahati High Court. The concerned authority is the respondent number 3, Registrar General of Guwahati High Court, who has to see that the promotion, recruitment, etc. of the concerned High Court establishment are held as per the applicable rules and procedures in force. Hence, the respondent number 2 has nothing to comment in the above matter concerning the issue of promotion, etc. made by the respondent number 3, that is Registrar General of Guwahati High Court. So essentially what the state is saying is that this is a matter, internal matter of the High Court, and we have nothing to say in the matter. So that being the state's position, madam, the lordship having requested me to address your lordship, I will perhaps have to address your lordship more as a amicus than as a advocate general.
That is precisely the reason you are the request.
First, your lordship will come to the prayer.
Yes.
In the repetition. There are two prayers. One prayer is to set aside the order of 2013, at which the respondent number 4 was.
He is not pressing that. Are you pressing? Are you pressing this prayer 1?
My lord,
This 2013.
Prayer
prayer, my lord,
Prayer 2.
2. Hello,
Because you are not concerned.
I will consult with prayer 3 only.
Prayer,
Prayer 1 and
1 and 3.
1 and 3, 1, 3 and 4.
Since he is not pressing on, I won't trouble your lordship. I
Yes,
will
yes.
just
You will record it.
Well,
First, if you know the.
Order of 2013 is not pressing.
Prayer to,
And even otherwise, just for academic purposes, Madam, this is covered by Rule 17 capital A of the Guwahati High Court rules, which confers power on the Chief Justice to transfer any of the officers from one bench to the other. So that is taken care of. Now, with regard to the challenge to the 2017 order, which is entirely founded on otherwise on reservation, but my learned friend during the course of his submission, he has opened up two different dimensions which are not really pleaded. So I hadn't really come with all the judgments, but I'll try to address your lordship on all the issues. My lord, what I find, the submission is twofold. First submission, as has already fallen from your lordship, is that Rule 8 of the Guwahati High Court rules provides only for reservation in direct recruitment, but not in promotion. So therefore, there ought to have been some provision made for reservation. And as it again has rightly fallen from your lordship, he simultaneously says that since there is no provision, therefore, this will, the reservation policy of the state as notified by the 2001 notification will apply. Now, I want to understand the dimensions in which my learned friend has taken his argument. We'll have to perhaps go back a little bit in history about how what was the constitutional concept behind the reservation. I will quickly, my lord, try and summarize. Although, as I said, my lord, I have not prepared in that direction. Your lordship recalls when the constitution was originally framed, so far as Article 16 was concerned, it stopped at Article 16(4). It did not have a 4A. That is when the matter went up to the apex court in the constitution bench, 9 judges, Indra Swami, where the main law that was laid down was that 16(4) deals only in respect of appointment, which means initial appointment. Prior to that, several states were providing reservation in promotions also. So in that context, Indra Swami said that there is the constitution makers never conceived of a situation where there will be reservation in matters of promotion. So whatever you have done, you have done. But these are all expressly unconstitutional. So that is when the 77th Amendment of the Constitution was brought in and 16(4)A was inserted. When 16(4)A was originally inserted, your lordship will recall, it was a replica of 16(4). Just the word appointment was replaced with promotion. In matters of promotion, was, if your lordship will quickly have it, have the constitution for a moment. If your lordship compares 16(4) with 16(4)A, your lordship will find the only thing that was added by the 77th Amendment was the word of appointments was replaced by in matters of promotion. And your lordship will not read with consequential seniority to any class, because this was brought in subsequently by the 85th Amendment. It was not 77th Amendment. So originally when 16(4)A was inserted, the word, essentially the word appointment was replaced by promotion. And two further words, in matters of promotion. Now this created further controversy. And your lordship is again aware, the next round of constitution bench, before the constitution bench, that famous Birpal Singh Chauhan came about. And that is when the phrase catch-up principle was coined. And this catch-up principle finally received the seal of approval, judicial seal of approval in Ajit Singh 2, which is again a constitution bench. And to overcome Ajit Singh 2, the 85th Amendment was brought in, and these words with consequential seniority was brought in. Now, thereafter also, again in Nagraj, thereafter again Jarnail Singh 1, Jarnail Singh 2. Right from Indra Sawhney up to Jarnail Singh 2, which is again a constitution bench. It has been repeatedly held that these are merely enabling provisions. It merely enables the authority or the state to make provision. And in Nagraj, your lordship is aware, from Nagraj, the reservation law itself has taken further turn, where this requirement of having a quantifiable data has been brought in. And that has again now become final. Now, it is one of the submissions that has been advanced by the on behalf of the petitioner is as if reservation in matters of promotion is a matter of course. It is not. It requires under 16.4a itself. If now we may read 16.4a, why Nagraj said requirement of quantifiable data. Nothing in this article shall prevent. So nothing in this article stops a state from making any provision for reservation in matters of promotion with consequential seniority to any class or classes of post in the services under the state in favor of the scheduled caste and the scheduled tribe. Now, this portion brings in Nagraj. In the opinion of the state. So if I may pause here for a moment. The first requirement is to provide for reservation. The state has to form an opinion. So therefore, in Nagraj, it was said that you will have to have quantifiable data in existence, in place. Because to form an opinion, you will have to have the quantifiable data. Now, next again is qualified, are not adequately represented in the services under the state. Now, from Nagraj onwards, as I was pointing out, this forming of an opinion has become a mandate, but that perhaps will not even come, will not even be required to be gone into in this case. Now, if your lordship again goes back to Indra Sawhney, your lordship will keep the constitution handy. One of the other things that was decided in Indra Sawhney by the 9 judges bench was that reservation can be made also by way of executive instruction. The legislature may definitely make, but it can also be made by way of executive instructions. If my memory serves me right, my lord, it should be paragraph 737 in Indra Sawhney, which is the majority there. Now, that again, if your lordship comes back to Article 16.4a, your lordship will find Indra Sawhney, why it said that it can be done by way of executive instruction is, if your lordship compares Article 16.3 with 16.4a, your lordship will find the reason. In Article 16.3, the language employed by the constitution makers is nothing in this article shall prevent Parliament from making any law. And now, if your lordship reads 16.4a, nothing in this article shall prevent the state from making any provision. So, when we compare Article 16.3 with either 16.4 or 16.4a, we see the reason why Indra Sawhney said that you can also do it by way of executive instruction. Now, in this context, if your lordship looks at Article 229, and your lordship will keep 16.4a handy simultaneously. Subclause 1 says, appointments of officers and servants of a high court shall be made by the Chief Justice of the court or such other judge or officer of the court as he may direct, provided that the governor of the state may by rule require that in such cases as may be specified in the rule, no person not already attached to the court shall be appointed to any office connected with the court save after consultation with the State Public Service Commission. Now, this says, subclause 1 says that, and there are judgments right from Guru Swami onwards, there are several judgments which have conclusively held that ultimately, when it comes to the functioning of the High Court, the Chief Justice is the ultimate authority, an absolute authority. So now, your lordship will kindly come to yes, subclause 2. My learned friend has tried to create a further dimension by reading subject to the provisions of any law. I'll come to that a little later on. Subject to the provisions of any law made by the legislature of the state, the conditions of service of officers and servants of a high court shall, this word shall has significance, be such as may be prescribed by rules made by the Chief Justice of the court or by some other judge or officer of the court authorized by the Chief Justice to make rules for the purpose. So, unlike in 16.4 or 16.4a, where it says that a provision may be made by the state, so therefore it can be done on by way of an executive instruction also. That mandate is absent in subclause 2. It has to be provided by way of prescribed by rules. So any matter pertaining to reservation in promotion, there has to be a prescription by way of rules made by the Chief Justice. So therefore, now in this context, if we examine the submissions advanced by my learned friend, under Guwahati High Court rules, the rulemaking authority, which is the Chief Justice in this instant case, has made a conscious decision to provide for reservation in direct. And a similar extent of consciousness has to be attributed to the Honorable Chief Justice on the administrative side while framing the rules of leaving out reservation in matters of promotion. So the moment this submission is advanced, that this executive instruction of 2001 will apply, your Lordship will have to hold first that there is a problem in the rules, and your Lordship will have to add not just one word or one sentence. Your Lordship will have to add a complete rule, which in terms of the settled proposition pertaining to interpretation of rules, statutes and rules, is wholly impermissible. Your Lordship will have to arrive at a conclusion that the omission is by way of a casus omissus. It is an omission by way of a mistake, or that the Honorable Chief Justice has overlooked. First, your Lordship will have to arrive at that finding, and thereafter add a complete rule similar to Rule 8, maybe as Rule 8 capital A or small a. A complete rule providing for reservation in matters of. So that, in my respectful submission, will be stretching things a little too far. And the other limb of the argument that this will have automatic application, that is not so for the simple reason, because it has to be prescribed by rules. Under Article 229(2), there has to be a rule. Without a rule, there cannot be any scope for any reservation in matters of home. Now that brings us to the other limb of his argument. My learned friend tried to interpret this first part in Article 229(2), subject to the provisions of any law made by the legislature of the state. Firstly, as has already fallen from your Lordship, there has to be a rule which is in existence. There has to be a law made by the legislature in existence. There has to be a conflict between the two provisions. Only then the law made by the legislature will override the rule made by the Chief Justice. Unless there is a law in existence, and unless there is a rule made by the Chief Justice in existence, then this portion of Article 229(2) will have no application whatsoever.
But he said this reservation policy by the state is as good as
No.
a law made by
Had it
legislation.
been as good as law,
Ah.
Indra Sawhney would not have said
Ah.
that it can be done by way of a.
Ah. No, that is his submission.
Well,
So he,
answer to that is in Indra Sawhney itself.
by accepting the reservation policy of 2000 of the state, he's saying it's a law made by the, as good as law made by legislation.
Well,
So since you have not provided a reservation by the High Court in the rules, it amounts to a contradiction or the inconsistency with the law made by the.
for there to be a
That
inconsistency.
is, I am not able to digest, I mean, I'm sorry to say that I'm not able to, I mean, grasp it.
And rightly so,
Ah.
with all humility, Malad,
Ah.
and with due respect to my learned friend. For something to be inconsistent, there has to be something in existence.
Yes.
When it does not exist, that is why my first part of the submission was that your lordship will have to first arrive at a conclusion, arrive at a finding that there is an omission. That omission is by way of a casus omissus, an omission because of an inadvertent mistake.
So we'll have to read it.
Your lordship will have to read it. That will amount to addition of a whole rule in the rules which does not exist, which is not permissible under the settled principles of interpretation.
So otherwise, he is saying, since there's a omission or there's no provision in the rules, that's why I've asked him again and again, that this, according to him, this reservation policy, which is the law made by the parliament, I mean the legislation, it automatically applies to the service of the employees of the Guwahati High Court.
That again will not be. Had it been, let us say,
Now, Mr. Lampu, is it correct?
I think that is what was the
That
purpose
is-
of this.
Yes, you are saying
It will.
it is as good as, it is a law made by legislation.
Yes, ma'am.
Since there is no provision under the rules of the High Court,
Ma'am.
it has to be, it is applicable.
It is.
Because the service, though under the High Court,
Hmm.
that you are serving in the state of Arunachal Pradesh,
Yes.
though may not be under the government. That's why I pointed out,
Hmm.
this applies to the services under the government of Arunachal Pradesh. But your service is not under the government of Arunachal Pradesh.
But
So you have to, that's why you are saying, since you have no, you don't have the High Court doesn't have the provision for reservation.
Hmm.
This state policy has to be, is applicable.
applicable.
That is his submission. Correct.
Had this portion not been there,
Hmm.
prescribed by rules,
Hmm.
even then one could have perhaps tried to accept it. But here, the constitution makers have specifically provided, without any ambiguity, that all conditions of service pertaining to employees and staff of the High Court will be in terms of the prescribed rules as framed by the Chief Justice.
Yes.
So the rules have to be in existence. Now, let us test his argument from another side. There is a rule in existence. He is trying to say that this notification will apply. Can an executive instruction override the rules? Can it supplement?
But he said, it's a law made by legislation,
No, it is not.
much more than the rule.
No. To that, my answer is, my lord, Indra Sawhney. Had it been, had executive instructions been at par with law made by the legislature, those 9 judges of the apex court would not have perhaps wasted so much of time and about 800 pages in the SCC to write this judgment. The lordship will kindly come to,
Reason is, why he's saying, because it's 162,
162 cannot be.
extent of executive power to the legislature. That is what he's saying.
My lord, if that argument had been accepted, Although there would not have been any requirement of legislation making any law. All actions could have been done under 162 had it been at par with law made by the legislature. This portion will make it clear.
Page.
Page
Paragraph.
688. The relevant paragraph is 737. And in fact, exactly what the difference that I was pointing out between Article 16.3 and 16.4 has also been dealt with in this paragraph.
Page.
Page 688.
688.
Why it was held that it can be done by way of executive instruction. 737.
Yes.
Even textually speaking, the contention cannot be accepted. The very use of the word provision in Article 16.4 is significant. Whereas clauses 3 and 5 of Article 16 and clauses 2 to 6 of Article 19 use the word law, 16.4 uses the word provision. Regulation of service conditions by orders and rules made by the executive was a well-known feature at the time of framing of the Constitution. Probably for this reason, a deliberate departure has been made in case of clause 4. Accordingly, we hold, agreeing with Balaji, that the provision contemplated by Article 16.4 can also be made by the executive wing of the union or the state, as the case may be, as has been done in the present case. Balaji has been followed recently in so and so and so and so. With respect to the argument of abuse of power by the political executive, we may say that there is adequate safeguard against misuse by the political executive of the power under 16.4 in the provision itself. Any determination of backwardness is not subjective exercise, nor a matter of subjective satisfaction. As held herein, as also by earlier judgments, the exercise is an objective one. Certain objective, social, etc., etc. This is not really relevant. What I was trying to point out. In this context now, if your lordship again compares 229.2 with 16.3, your lordship will see the difference. Your lordship will see the similarity rather. 16.3 speaks about law made by the parliament.
I think for the petitioners, 738 is also important equally. Para 738.
Yes. That question was slightly different. Here, Mr. Ramjan Khanani had argued that till a rule under 309 is made, it has to be kept on hold. In that context, the Constitution Bench answered that no, till 309 rules are made, these executive instructions can have immediate application. It is slightly in a different context. The similarity your lordship will find between 229.2 and 16.3. 16.3 also speaks about Parliament making a law, and 229.2 speaks about legislature making a law. And it was this difference that was noticed by the Constitution Bench in Indrasoni at para 737, and therefore it was held that since 16.4 does not talk about law made by the legislature or law made by the Parliament, it speaks about a provision. So therefore it can be done by way of an executive. So that similar language has not been employed in 229.2. 229.2, the framers of the Constitution were very clear that it has to be.
Therefore, any notification under 16.4 or for that matter 16.4a may be enforceable, but
Yes.
this is not a law made by the legislation.
Yes.
There's a difference.
And it will not have automatic application to the High Court services. For the simple reason, it can be done only by way of prescription in rules
By the
by the Chief Justice.
Chief Justice.
So therefore, my lord, looked at from both the angles, I am not, my lord, even for a moment treating this as an adversarial litigation. I am just trying to.
Yes.
I am just trying to assist your lordship to arrive at the correct conclusion.
Yes. Yes,
So therefore, my lord, to summarize, firstly, it will not have automatic application because 229(2) expressly says that it can be done only by prescription in rules made by the Chief Justice. First reason why it cannot have automatic application. Second reason why it cannot have automatic application is that in this particular case, it is not that Guwahati High Court has not framed any rules at all. There is a Guwahati High Court Service Rules of 1967 in existence. Here, the Chief Justice has made a provision at Rule 8, providing for reservation in direct rule. So the omission, there is always a presumption in favor of rules. So the presumption in this case will have to be that the omission not to provide for reservation in promotion is a very conscious omission. And therefore, that is the second reason that the reservation policy of the state cannot be imported into the rules of Guwahati. So looked at from both the angles, and it is a different matter to say that it ought to have been provided. For that, the prayer itself will have to be completely different. That is not really the prayer. So therefore, my lord, in my respectful submission, although matter pertains to reservation, it is not really that complicated an issue.
yes. The only what we want to say is whether this reservation policy of the state, and not that whether they could have been reservation or not, whether this will apply automatic to the services of the employees of the High Court, that's all.
That's the only issue.
That is only what that is according to
If it applies,
according to him, there is no provision in the rule, this will apply.
even if it applies, my lord, then now, if your lordship will kindly have the Guwahati High Court rules for. Assuming for a moment, my lord, hypothetically speaking, assuming we reach a stage where we are able to conclusively say that the omission is a conscious omission. If your lordship will kindly come to Rule 8.
Yes. 40.
647.
647. Yes.
Scheduled caste, scheduled tribes, other backward classes, and more backward classes. To secure better representation for scheduled castes and scheduled tribes, 5% of the posts to be filled up by direct recruitment shall be generally reserved for scheduled castes. 10% of the for members of scheduled tribes. Now, the other thing your lordship will have to do will have to be an insertion that it will be 50%. Now, even while providing for direct recruitment, the percentage provided for is 10%. So not only will your lordship have to read a rule providing for reservation in matters of promotion, your lordship will have to provide for something which has not even been conceived of even in case of direct recruitment.
So that it ought to have prescribed.
Ought to have is different. It's in a different context. Perhaps on the administrative side, perhaps if a repetition is filed, making such a prayer, that this is an aspect which has been overlooked. It is a case of casus omissus. Therefore, a direction should go to the High Court to amend the rules. That will be in a different context altogether. For that, one of casus omissus will have to be pleaded. It has to be established. Only then your lordship will go to that extent. But this is not a case, perhaps. Not only will, as I said, not only will your lordship have to read it into this rules, reservation from promotion, but also the percentage prescribed.
Otherwise, in other words, he can challenge the rules also.
Yes, he can challenge it.
On the basis of renewal. What about this judgment of?
My lord, I was coming to that. That was the last limb of my argument.
Yes.
That cannot be construed as a direction for a simple reason. it will become par incurium to all the judgments after Nagraj on reservation. And in a recent judgment, I'm forgetting.
In fact, it doesn't talk about the reservation. It talks about only the concernments with the Article 14 and 16.
Yes.
And when you read it, you should also agree with it. This talks about 14 and 16. And 16.4 and 16.4a, 4.3, it's a different provision.
Because
That's why it's a enabling provision. So you have read it.
That is
It's
true.
only 15 and 16.
Yes, ma'am.
Consciously, because 16 is equality, the public employment. Then 16.4, where the reservation enabling provision is there, it's consciously been omitted by not been mentioned by the Honorable Supreme Court. It talks about 14 and 16.
But in Renu case, my lord, direct.
You cannot just because this is 16.
Yes, ma'am.
That's why I'm saying it about Renu's case only. Is it talks about 16.4? Let us see. 16.4 is not.
My lord, it is talk about reservation. Ma'am. It's specific, ma'am, reservation. If
Is
there
it?
is no any, my lord, reservation, my lord,
Is it? I don't think so.
fourteen and 16, ma'am. This talks about.
Yes, 14 and 16, that's right. It's not 16.4. 16.4 is stated in the different.
It cannot be for the simple reason, my lord.
You
There cannot be a
direction to back a reservation.
Because
That's why it's an enabling provision.
and your lordship is aware, recent judgment 2020, I think it is Mukesh Kumar, where if I'm not mistaken, it was Gujarat High Court, the state of Gujarat or one of those states, which had not made any provision for reservation. The High Court directed that you collect quantifiable data and you make provision. When it went to Supreme Court said that no. Because 16.4 and 16.4a do not confer a fundamental right. It is only an enabling provision. So therefore, the High Court was not right in directing them to collect quantifiable data for the purpose of providing this. So therefore, these paragraphs 34 and 34.5 certainly cannot be construed to be a direction to the High Court to provide for it.
But it is desirable that provision should be there.
It is desirable based on forming of an opinion.
Yes.
In the case of state employment, state service, the state has to form an opinion. In the case of High Court service, the Chief Justice will have to form an opinion based on quantifiable data. And if it is found that it is necessary, it is not adequately represented, then definitely it should be provided. There's no question about that. But for that, Malak, the entire pleadings, the entire prayer will have to be different. That is all.
This about this Renu.
That is what is my opinion. It cannot be considered as a direction because it will violate. It will be par incurium to. I'm sorry to use the word violate. It will be par incurium to all the judgments rendered from Nagraj about requirement of collection of quantifiable data and thereafter to provide for reservation. And
No, that's why I'm saying that it talks about 14 and 16 only, which is obvious.
which is
Doesn't
more about
include-
non-discrimination.
This is non-discrimination and all those rules, the equality.
Exactly.
It doesn't talk about ours. That's why I looked at it. He said talks about reservation also. It doesn't say about reservation, Mr. Lampu. And there cannot be.
Hello, this talks about
To
article
have a
14 and
reservation. huh?
14 and 16. my lord.
Ah.
Yes, my-
14 and 16,
yes, my lord.
agree.
But
But it's not about 16.4.
my lord,
16.4 is something different.
my lord,
It's just an enabling provision.
yes, my lord, that's true, my lord, that's 16.
When you say 16, it doesn't include, as per this, there's 16.4, unless it is clearly mentioned. There's a reason
Yes,
why this cannot be, 16.4 cannot be. It's an enabling provision. There cannot be a
In fact,
direction, even the suggestion.
Lord, that is true, this 16.4 is another provision, my lord. But my lord, can we, my lord?
No, when you
exclude
say
the clause-
16,
clause 4 from
Article
16, my lord?
16, see, when you say Article 16,
Yes, my lord.
it's not necessarily always Article 16, 2, 3, 4, and 5, 6. Especially,
in my
forget
answer-
about 1, 2, 3.
Yes, my lord.
4 and 5, I mean, this cannot be.
My lord, in my humble submission, my lord, 16.4, clause 4 cannot be excluded from 16, my lord, in my
No,
humble submission.
so far as this direction is concerned,
Yes.
it doesn't include 16.4. Had it been, they ought to have been, I mean, they would have mentioned it. Anyway,
But such a direction would, I am not carrying it, obviously it has come to my mind. Your Lordship may just, for our academic purpose, if your Lordship so desire, there's a judgment of the Supreme Court of 2020, Mukesh Kumar,
yes.
where this kind of a situation that I was just pointing out. That a direction was issued by the High Court that you make provision for
No,
reservation.
this court is very clear about this.
That cannot be.
Renu's case, I'm very clear. I don't know.
It cannot be construed as that.
I'll take a call that is, I'll determine it, something
But-
different. I think, okay,
Deeply obliged.
sir, anything to say?
Whatever to be raised against the writ petition, I have already given in affidavit in opposition. Then after that, just to remove the doubt, just to remove the confuse,
Yes.
I will place one ruling and this ruling will suffice to decide this case.
Yes, it's okay, that's better. Why to waste time, no?
Yeah, yes. Instead of going, I'll directly go to the rulings. Now, the power of the Chief Justice is neither a absolute nor unfettered. However, no court under Article 226 of the Constitution of India has the power to direct the Chief Justice to frame or formulate rules or make appointment for a particular purpose, since that would mean impinging on the discretion of the Chief Justice. In other words, although the court has every power to examine the constitutional validity of the rules framed under Article 229 of the Constitution of India, but it cannot issue directive to the Chief Justice to the frame rules for the benefit of a certain section of the society. To put it in the other words, no writ of the mandamus would lie against the Chief Justice to legislate rules under Article 229 of the Constitution of India. Full bench cannot issue a directive in the nature of a command by way of writ of mandamus to legislate to frame rules for the scheduled castes, scheduled castes, scheduled tribes, and backward classes, reservation, that would be the prerogative of the legislative itself or the Chief Justice, and the court has no say in that regard. Hence, such series of mandamus cannot be issued to the Chief Justice to frame rules to provide for reservation in the promotions of the
Bombay
High
High
Court
Court.
employees. Now,
Bombay High Court.
yes, now,
It's not binding on this court.
but even it may be of a Bombay High Court, but they have quoted the ruling of the Supreme Court.
You saw the ruling of
Yeah,
the Supreme Court.
this is a course entitled. Now come to the para 23. Para 23.
Sir, I have read it. I've read it.
Okay, then para
You just read the conclusion.
para 24, para 25, para 26.
Yes.
And in the part, para 26, it is clear,
Last is para 27.
para
You read the
27.
para 27.
So this it covers the case. So this court, being a single judge, can direct the chief justice, can pass any direction can be given to the chief justice.
No, that is.
That is the law.
Just can
And
direct.
that is the prerogative
On
of
the
the chief justice.
administrative side, with the.
Yeah.
This court can.
Yes, that is the prerogative. Here in
Not as
the,
the chief justice in the judicial side.
no, as per this ruling.
Administrative side, we can.
As per this ruling, there, this what regarding the promotion, and there we shall silent of the reservation. In that case, Chief Justice is the only final authority to exercise
This
this.
judgment says that the full court of the Bombay High Court says that under article, exercising the power under Article 226, the court cannot direct the Chief Justice to frame a rule or provide a reservation policy.
By quoting the Supreme Court
by
ruling,
making it. Yes.
by quoting the Supreme Court ruling, that is not only.
So he is not asking for, his prayer is not for,
Yeah, his prayer is.
no,
there.
we'll go by the.
His prayer is there.
Sir,
His prayer is there.
just
There
listen,
is no reservation.
just wait. He is not asking for framing a rules, providing reservation. He is saying that the reservation policy of the state
Will not apply.
will apply.
Will not apply.
So
Because
you,
229.
can you-
Yes, 229
can
is
you-
only for the men, for the
Sir, can
independent
you-
of the judiciary.
just wait, can you elaborate that why it cannot be applicable? Why it should not be applicable?
High court is not the employee. They cannot make the rules for the
Yes.
employee of the high court.
Yeah.
High court is an independent.
Okay.
So whatever rules and reservation policy they have adopted, it is applicable to only state employees. It will never apply to the high court,
Yes.
high court employee. That is the only,
Because the High Court is independent.
the high court is independent. And whatever decision has been passed by the chief justice, it becomes the final. That much.
Sir, may I request all the parties to give your written submission?
Written.
In fact, I had already prepared
It's okay, not today. We'll make it CAB. Let me have a privilege to go through all those provisions. By Monday, you can give the written submission. whatever.
So,
Because sometimes
yeah.
we keep it, when you keep it reserve when you reserve the judgment, we tend to forget.
I've got a lot of rulings, but I don't want to make it a lengthy.
Not lengthy one, you give your short one, whatever you have submitted, that's all. One. So. Reserve the judgment. Or Mr. H. Lampur, and counsel for the petitioner. Whatever this respondable 3, 4, and 5, nobody appears.
The last occasion they have.
Also heard. Mr. Aichodi, London Advocate General for the state of Arunachal Pradesh. And Mr. M. Partin, London Senior.
Appearing for 3 and 6.
Senior Counsel. Standing Counsel.
Standing counsel.
Standing Counsel for London Standing Counsel for. Respond number 3 and 4.
3 and 6.
3 and 6.
3 and 6.
Okay. Not appears for respond number 4 and
4
5.
and 5.
4 and 5 are private.
Hearing concluded. Judgment presented.
Right.
If you provide us, if you can provide by Monday. State this,
My young friend will submit.
by Monday, yes, all of you may submit. To the, I mean, bench clerk or to registry. Wherever I'll be.
They can
that will
transmit.
be transcript. You just submit it. You may submit here and they will transmit.
All right.
For the, I think it's 16. So, yes, I have, there is, so I'd like to, we do the,
Is it?
yeah.
I'm not pushing, huh?
Yes,
I'm not pushing, but then,
So what I
according to the view of the opinion of this court, is
No,
not a
but-
case for a question.
No, I humbly accepted, and I feel. that
That's
I
why I've
think
given,
it is
given you a
come
chance.
more-
You might have checked the order which I have dictated, recorded yesterday that has been changed. I said simply, because that will be too harsh for you. Then I said, on the prayer of learning council, because I have recorded some,
Yes,
dictated
yes.
something. So while signing, before signing, I've changed it. I said, you can check it.
No, my lord.
That it should not have,
That is-
court's opinion and should not have some ramification to the career of the lawyer. That is what this court believes.
Most of nice, madam.
So it's up to you.
So I'd like to withdraw the, with the liberty to file appeal.
Liberty cannot be, because it's a criminal petition. You may file it.
With the liberty, just after withdrawal, I can sign it again. Okay, then.
Heart, Mr. MD for London Council for the, there is 16, no?
Yeah, 16, this is, I don't know.
For the petitioner and also our Ms. Jeeta, the London Council for the London additional public prosecutor question. The London Council for the MD for London Council for the petitioner submits that he may be allowed to withdraw this criminal petition. The pair of the London Council with petitioner list of accordingly, the criminal petition is disposed of or withdrawn.
And I have returned the LCR, which I took yesterday, already returned.
So this is a original LCR,
Yes, also original.
so send back the LCR. Huh? Send back the LCR.
Probably.
Most of like.